Welcome, everyone, to this edition of the Mediate.com podcast. I am Colin Rule, CEO of Mediate.com, and I'm delighted to be here with two of my good friends, Peter Salem and Kelly Olson, to talk about their incredible book, Family Dispute Resolution, Process and Practice. I'm holding up a copy of the book here, too, my well dog-eared copy. Thank you so much for being with me, the both of you. I've been really looking forward to this conversation.
I have too. Thank you for having us. We're excited to talk about this.
Wonderful. Well, how many years of your life did you put into putting that? I mean, this is an impressive tome. I mean, you could use this to block a heavy door and it wouldn't shut. So how many pages are we talking about,
632.
Amazing. How many years of your
counting the
life
index.
did this
Well,
take?
it was four, okay, 4, 5.
We
4 or
5.
4 or 5.
We started in 2020, signed the contract just a few days before COVID shut down the world.
Okay.
And then I guess got published in 2024.
So that'll date it, the beginning of the pandemic. Yeah.
Yeah. Oh, absolutely. It was a great, we were actually switching publishers.
Oh, okay.
As at the outset, this was originally going to be published by another publisher, and when COVID hit, the editor from that publisher was just disappeared.
Well, the whole world was like, are we even going to have, cars in the future?
We heard
it was a little bit before that. It was January and February that the other publisher released the editor who was working on our book, and the new editor was a no-show. And so then we got in touch with the people at Oxford right as the world was shutting down.
Oh, wow.
At the beginning of March.
Now, whose idea was it originally to kick this off? Did the two of you? It was Peter's.
Yeah, this was mine.
That's great.
It's really, I think, a reflection of what has happened over the 30 years I spent with AFCC, the more than 30 years I spent with AFCC.
I did sort of feel like this. I mean, again, Kelly, you have many, many years of productive working ahead of you. But Peter, you are coming to the end of the AFCC chapter, and this is sort of your AFCC chapter. And this was sort of, summarizing all of the incredible work and changes that had taken place under your watch. Was that part of the motivation in writing the book?
It was. I'd wanted to do it for quite some time, actually. As I was finishing and the family and divorce mediation book that I did with Jay Folberg and Ann Milne, which was published in 2004. That same year, I wrote an article for the Wisconsin Law Journal, which was something along the lines of resolving family disputes. It's not just mediation anymore. And started thinking, and I was doing some work in the Connecticut courts at that time, just started thinking about the diverse approaches to family dispute resolution rather than mediation, which was really how I got into this, how I think Kelly got into this, and what our backgrounds were. And we were so tied into that one process, but we saw all sorts of other things evolving. So when Guilford came back for a second edition of the Family and Divorce and Family Mediation, we said no. And that was about 2008. So it only took 16 years.
Only 16 years,
from the idea to the fruition.
Well, I think this book is an incredible snapshot of so many different sides of how the field has grown and evolved, parent education and child inclusive and parenting coordination. And I mean, it's amazing, really, the scope that's in here. And this is a very difficult thing to do, to take a snapshot of a field that is expanding so rapidly. Who did you originally think would be the audience for this book? Who did you write it for? When you were working on it in your head, who did you see picking it up and reading it?
I think it had several different audiences. And I think Peter and I went back and forth on chapters. I think originally our proposal was 26 chapters, and we could have done 35. Wow. There's topics that aren't in here, but part of it is who is the audience. And I think we really wanted young and upcoming professionals in this area. AFCC, for those who don't know is the Association of Family and Conciliation Courts. And
Right.
it's a really important organization in the family world. For one, I was attracted to it 30 years ago because of Peter and the idea of this interdisciplinary piece. I was in grad school at Loyola, having done law school and some corporate law, and was back in the family and child welfare area, and was so impressed with AFCC being so interdisciplinary and valuing the input of therapists and judges and mediators and social workers and evaluators. And it such an interdisciplinary look that we knew we wanted this book. That's been such an important part of AFCC. We wanted the book to reflect that. And so the audience is interesting. And Colin, with your projects, I know you have this too, sort of, who are we appealing to and how is it going to work for them?
Right.
And can it still work for other audiences as well? And so we thought about grad students who are interested in getting involved in marriage therapy, in law, family lawyers, family law students who are studying family law and want to know about how expansive it is. It's been great to see as a law professor that family law has expanded to include some of the social science. The law is still a little bit behind, but it is catching up with the importance of having these other areas involved. And so Peter and I had multiple discussions about, who are we writing the book for, and talking to our chapter authors about who we want it to appeal to, because a lot of them have a really high level of knowledge, and we really want it for people who may not know that family arbitration, for example, exists.
Right.
There's some people who think of arbitration and business disputes and don't know how it has really come about more in the family area. So we think the audience who it should appeal to are grad student classes. I'm excited. I'm teaching a class based on it in the spring for law students who already have family law, but now they're going to get to learn more about all of the different aspects beyond just the book law, beyond the black letter and the statutes, but also in grad classes. But for the young professional who maybe didn't know they were going to go into family law, and they are, or they are involved because they're a therapist and they get called to be an expert witness, or they get called to work with children who are going through this process. One of my favorite chapters, I think the most important, is on the working with parents of children with special needs. It's done by two of the premier people in the field, but really talks to people who don't know that these families go through extra layers of conflict during their divorce. So it's things like that that I'm excited to bring to anyone, but I think a young professional might not know that with all of the other training they've received.
Well, and again,
I would add,
please, Peter.
I would just add, I have a one-word answer to your question, which is I think it's for everybody. And just because what Kelly just said is really important. You can have all sorts of expertise in this field, but there are things in this book, special needs, LGBTQ plus community, cultural issues. We had a lovely note from Nancy Rogers, who I think knows everything. And she read an early draft of the book and said, she had learned a tremendous amount, which was as great a compliment as I can imagine, because the breadth is so astounding, quite honestly, that the expertise of the chapter authors so great that very few people can know in depth what's between the covers, because there's just so much, and no one person, I don't think any one person could have written this book.
Well, I agree with that. I think it's interesting also what Kelly said about teaching from the book. One of the questions is, do we want to write a 101 textbook, like an introduction from ground zero, somebody that knows nothing, or a book that's like a 401 or a 501 class? If Nancy can read this book and get something out of it, I think it's easier in a sense to write a book for one very specific audience. It's harder to write one for everyone because you just want to pack everything possible in there. But there's so many different pathways through the book. And I should say too, our aspiration is to do interviews with as many of the chapter authors as we possibly can, because we want to go deeper into each of these chapters, because there's so much substance and expertise in each chapter. I think, any of these chapters could have made probably their own book talking about that topic alone. So
Like Peter
I
said, they are
think that
experts, and some of them are very excited about getting to do the podcasts and talking about more about, what went on with their chapters.
Great, great.
But I would also say that that as in depth and as much expertise as some of these chapters are, they're really accessible. It's
Mhm.
not a lot of jargon. It's not a lot of language people aren't going to understand, so that you can get something different out of it, no matter what level you're
Yeah,
operating.
and in fact, to extend Peter's point is, I was talking with Susan Guthrie at the ABA, and we were talking about how for some parties going through a divorce, you would recommend it to them if they really wanted to learn more about their aspect of it, or have them work with a professional who gives them one of the chapters to read,
Mm.
because it is that accessible that people should be able to read it, who are just really interested in what this whole process is going to look like for them when their family goes through it. And obviously, they're not going to need to read all 29 chapters, but there's quite a few that apply in multiple situations.
Or like you said, the special education, type or special, that like if someone had that particular circumstance, that's a great
Yeah.
chapter for them to pull out and do a deep
Yeah.
dive into. So
Yeah.
I want to talk about the structure of the book, because there's so much information here, so many topics. And you do talk in your introduction, you talk about how the whole notion of family dispute resolution has evolved so much. I think you'd say in the 60s, it was still pretty much fault-based, and then it's amazing to think over 50 years, how many new areas of practice. So talk about how you structure it. There's 8 separate sections in the book. And did you intend to create kind of a narrative line through the sections, or was it like, how are we going to group things so that people can find the topic that's most
It's
valid?
when in the 4 years you're talking about. I think there was definitely some evolution from our part too in looking at what people wrote. Right. And so we had an idea based on, and we went to these established authors and had some ideas of what we wanted to include. And then there was some back and forth on them on what they thought was primary in their area. And then we had sketched out an idea that we wanted, and maybe Peter wants to talk a little bit more about that, but it was very interesting because we did do some switching around once we had the chapters to kind of figure out where they fit within the context of the topic, and I think we changed topics a couple of times, Peter, to
Oh my
encompass
gosh.
some of the chapters, right? So do you want to talk a little bit about what
Yeah,
we were
I mean,
thinking?
well, I think we started the book, and I think the entire field, it kind of starts with mediation. And mediation is a foundation for not only the book, but for a lot of the practices that exist that are in the section 3, which is beyond mediation, which is really, I think, in many ways the heart of the book. So we wanted to begin with a really thorough look at mediation, and with a couple of really what we thought were critical points: the self-represented litigants and the child inclusive mediation, which are things that really continue to persist to this day. We did not want to get into models of mediation practice, who's doing it right, who's doing it wrong, those kinds of things. I think we both agree are passé. But we were then able to build out the beyond mediation section with a lot of the innovative practice, and I will say some of the top people in the field writing about them that really had a base in mediation. And so that took us. Kelly, you want to pick up on section 4 and how we got the rest of the way?
We did want to talk about, that there's a lot more out there than mediation. And then we wanted to talk about some of the critical challenges that we think face mediators and judges and parties these days. And so you've got Bill Eddy, who's an expert and talks about high conflict personalities. You've got intractable conflicts when you're dealing with high conflict families, that was written by Robin and Matthew. I talk about intimate partner violence, which was a tough chapter to write, and Peter was great a great help, but there's a lot of different tools out there. And it's hard because Peter said, you're saying screening a lot, Kelly. And I would say, because they need to screen, and they need to screen at the beginning, and they need to screen in the middle, and they need to screen at the end. And so while Peter's right, we don't talk about caucus model or other models. We do, everybody gets the chance in their chapter to talk about what works, what they've seen work best in their area,
Mhm.
and how it works. So it's not a how to mediate, it's what process
Right.
are you choosing? And if you choose a process, what do we think should be included in it? What does it look like?
Mm.
And for me, with the IPV chapter, that was, I think, so important. And just to hark back to what Peter said earlier, one of the chapters that one of our reviewers said should be up front because it's important. There's so much bandied about IPV, and there's so many people who think, I know what it is when I see it, I can identify it. And what I'm here to say is, I've been doing this for over 30 years, and I don't know always what it is when I see it. So
Absolutely.
aware of all the possibilities and the very dangerous cases, and what maybe shouldn't be mediated. And there's not a lot of mediation books out there that say, don't mediate. But
Mhm.
that's part of what's in my chapter, is there are cases that should not be mediated by the highest, most competent mediator.
Mhm.
And I think that's important to say. We're talking about when to use what processes, when maybe not to.
Mhm.
So it goes beyond that. But then also, I think the substance abuse disorder, which has been a unfortunately ever rising part of family cases and really needs to be talked about. How does this impact how people are negotiating with each other, what the processes look like for them, what can be helpful for families that are a little bit lost with how to proceed when there's a mental health or a substance abuse issues. These things can be really helpful.
Mhm.
These
Mhm.
ideas, I guess, can be very helpful.
Well, there's so many things that I want to respond to on what you said, Kelly. I do think mediation obviously is changing. Mediation has changed over the decades. Our understanding, I got involved with mediation initially in the late 80s, and now my understanding of what mediation is has completely evolved, but also the world around mediation has changed. I think our understanding of mental health issues, our understanding of the diversity of the parties that we're supporting, and I think that that's one of the things the book does really well, is talking about the evolving understandings surrounding mediation and how that's evolved our practice. One of the things I want you to talk about was sort of the evolving role of lawyers, because I think lawyers played a very central role, and now there's many other people who are involved in the process, and that's something you address too in section 4.
I I will just say that with regard to section 4, we very specifically we labeled it collaborative advocacy. I don't know that we're the first person to use that term, but we were very deliberate in not having collaborative law or collaborative practice or collaborative divorce. I'm not sure what it's going by these days, as a separate process, because we really viewed that as one of many ways that
Mm,
lawyers could advocate for their client in a collaborative way, sort of the Julie McFarland new lawyer approach to lawyering. And so Kelly took hold of that section for the most part, being the lawyer, and since I'm not. But I love that section. I think it's got really excellent chapters written by some of the top people, and is well, you're going to teach that to your students, I assume, Kelly.
That's a big part. That's a big part of what I'm doing, because I think that, one of the things, Peter, on one of the projects I did for AFCC years ago, we were talking about helping mediators work with at the time they were unrepresented litigants. Now we call them self-represented litigants. And that we were worried because they were less prepared than lawyers. So we went to talk to lawyers about how they prepare their clients for mediation. Turns out not so much, which is problematic, right? But what we learned is that you can't rely on someone being represented, meaning they're prepared for the process. And so how do mediators kind of prepare people for the process? And what are the other processes that might be beneficial for your client if you are a lawyer? If you are someone working in a court system, I mean, that's what I love about this book, is that's maybe the population we didn't talk about yet. It falls under Peter's everyone. But, if you are working in a court-connected system and wondering about different processes that you can get involved in, we know that the highest, that it ranges depending on the jurisdiction between 50 and 70% of the people involved in family law cases are self-represented. And so it's very difficult. Attorneys will tell you all the time that it's very difficult to deal with a self-represented person on the other side. It's also very difficult for court personnel to deal with self-represented litigants. And so in this section and elsewhere, we have some help for that, or what that means, what that looks like, but also how can you be, the question that comes up for me with litigators and mediators is, can you zealously advocate for your client in collaborative law or in mediation? You absolutely can. It is not the same. It doesn't diminish an attorney's ability to zealously advocate for them, for their clients. And this, I think this group helps to see what are the varieties. In many jurisdictions, there's an ethical rule that attorneys must tell their clients about alternative dispute resolution. What that means has been interpreted in 1,000 different ways, but these are ways that attorneys can learn about what other processes are available. I also think it makes sense to think about not pie in the sky, any option out there, because that's not true in all jurisdictions. Both of you have seen jurisdictions that have a variety of sources, a multi-door courthouse. You can do a lot of different things. And there's more sometimes rural, smaller communities that don't have the resources. And so they don't have all of the options. So what are some things they can do without having all of the options, ways to help people? How do you advocate for clients in a situation where you don't have as many resources?
Well, it was interesting. We just had a conference at Stanford 2 weeks ago called Future DR, talking about the future. And we had a bunch of judges there. And one of the things, I think it was one of the professors at Stanford said, is that the model, the adversarial model, has completely failed in family cases. And it's interesting, one of the things that you trace is the evolution of that model. And when you talk about zealous advocacy, Kelly, that's interesting because, as you say, I think the rules in courts are changing now because the majority of the people involved in family cases are, and we talked about unrepresented, self-represented, and a lot of the court staffs are reluctant to give them advice about what they need to do next because they're worried about unauthorized practice of law claims and things like that. So if we were designing a system that's based on advocacy and lawyers are involved, we design one system. But if the reality is, I think they say 70% of people involved if 70% of family cases in the United States involves at least one party that's unrepresented. So if we're designing a system around that constraint, then maybe putting lawyers and adversarial models at the center of it is not the right way to think about this. And I think that's tracked in the book too, is the evolution of understanding about how best to support people in that reality.
And one of the in-between places, one of the in-between places is that unbundled legal service that Woody Mostyn talks about so well, which is just representing people for a part of it. And people can afford that and they tend to like it. And attorneys just need to have a lot of safeguards in place that Woody talks about if they're going to do a model where it's not full representation. Sorry, Peter.
Peter, please.
No, and I was just going to say, Colin, you were leading right into Section 7. If you were going to design a system, I love Section 7, largely because I was a court services director back in the early 90s, and we had one hammer, so everything was a nail, and that was mediation. And I can still recall doing the orientation with people, and it was really a sales job, and it was an easy sales job because I believed in it, I loved it, I thought it was great, and I still do. But the reality is there's so many different ways to approach family disputes. And actually in the first chapter, Kelly and I and our co-author Abby White suggest that maybe what we should be doing is having, rather than mediators or parenting coordinators or what, that people should be trained as family dispute resolution specialists, and that they have a broad range of skills, and that they come into a system or an office or wherever they are, and there is some triage mode that identifies what their needs are. And it may be that information is very important to them. It may be evaluation, it may be self-determination, whatever it is, that people actually are able to design and pick a specific process rather than saying you're going to mediation here, you're going to evaluation here.
Mhm.
These 4 chapters really have different ways of helping people identify, design, and work through processes. I especially love the Family Resolution Specialty Court, the chapter by Marsha Pruitt, Linda Fidnick, and Noel Stern in Northampton, Massachusetts, because it is a process design in which a judge is participating throughout, but not as a decision maker, as a process facilitator, using the weight of the bench, right? Because these are folks who are not easy and who really need to be there's some arm twisting that needs to happen.
Mhm.
But as an authority person who is helping facilitate a process rather than simply making a decision, and solving a problem rather than making a decision.
Well, and that makes me think of Jim Williams and what he's done with, judicial early evaluation, sort of an ARB meet ARB model, or a evaluation facilitation evaluation model. I mean, it's, as I say, the innovation is really inspiring because people are still exploring new models. Well, so let me just ask, what was something you learned over the course of this book? What was a surprise in reading these chapters? I mean, you both knew so much about family dispute resolution before you started. Was there something that, what was an insight that the two of you gleaned from your editorial role through this process that you didn't expect that you would encounter when you started it?
Well, one of the insights was how dedicated and how smart and how much people know what they're willing to contribute. Nobody's getting paid for this. This was not at the top of their list. We got hit in the middle of COVID, and somehow we got 40 plus of the best experts in the field to really roll up their sleeves, think about things in a new way, and contribute. And I have made a career of herding cats. So I wasn't new at this, but this was a special group, and so for me that was a great insight. It's just how much dedication the best people in the field had to this project.
Yeah,
Yeah,
and we didn't get to
this.
talk about, we still got a couple more sections to talk about, and I would just say connected to this is when we talk about, I think Peter started talking about the importance of cultural and diversity, which is our section 6.
Right.
There's 3 pieces in there. There's culture by Gitu, who is amazing. There's the children that we already talked about, special needs, and then there's Alan Barsky, who wrote Gender and Sexual Orientation Matters. And I knew a little bit about all those topics. And I would even say, if someone asked me about it, I would think that I was informed on those topics. I've spoken about them. But just the level of detail. And I think, for Gitu, one of the things talking about cross-cultural issues, and that we're not just looking for cultural competence, we're looking for understanding, and how important it is for the mediator or whoever is working in the family dispute field when they're talking to these families to be thinking about the intersectionality of age and culture and location and all of those things I think are key. And I think that fits with all 3 of these topics, is that it's not linear. And that's why, the social science in these cases are so important, but you've got parents who have a child with special needs who both adore their child and have very different visions of what's next for the child or what's next for the family. And unfortunately, the rates of divorce of families with children with special needs is higher than average. And, all of the multiple problems that our LGBTQ TIA plus people go through because the law is so far behind in some ways how we define family. And so those sections, I think I just learned, you think sometimes, and especially when you've been around as long as the 3 of us have in this field, and you can just learn so much more.
Well, and in section 8, you talk about some of the challenges of, writing in such an interdisciplinary field, and obviously, Kelly, you're an academic, there's been a lot of research. Actually, Peter, you hooked me up with Amy at Indiana on some of the great work she's done with IPV screening, but there's so many different fields that fit into this and that's one of the things I think that's evolved in the understanding of family dispute resolution is the role of all of these different fields. But Kelly, can you talk a little bit about, sort of trying to do research in something like that and sort of where we are with the research and what
Yeah, I
research you
mean,
think still needs to happen?
we know, and I'm sure you know from your work with Amy, like there's a dearth of information out there. She's one of the people doing great work. Marcia Klein Pruitt, who we have in this, is one of the premier people on it. And unfortunately, she was one of the people who really wanted us to get this published early because she did great work early on, and we just were not getting everything else done. I was not getting everything else done. But her work shows the gaps, unfortunately, in the research in some of this area and how we need to do more interdisciplinary research, because what some people say are research, if you dig down far enough, it's not evidence-based research, right? And so even the definition of what's evidence-based and what it means can be a dispute in this area. So I think thinking about the multiple perspectives and how they approach research. I mean, one of the things that, and Colin, I'm sure you know this from all of your work too, but I also work in the child welfare world, and we had some great research that came out of the NCJ, FCJ, the National Council of Family and Juvenile Court Judges, in the 80s and early 90s. But we don't know what's going on in that field now because there's just not a lot of research. I think if research can also let people know about other opportunities, sort of like we're talking about the book. So we need more studies because some of these types of programs do cost money. But one of the things, if we go back to chapter 26, which Marcia was also on, and Linda Fidnick and Noelle Stern, talking about that family specialty court and how it works, is we're doing preventative stuff there, which is kind of funny for a court, right? Connecting it to drug courts and other areas, but we're preventing future disputes, saving litigants costs, but there are upfront costs. So to get back to your point about research, we need research to show, you know what, the time that you spend on this case that's more than other cases is worth it down the road as a court resource, as a family resource, as a society resource. So,
well, if we are going to discuss research, I can't let this part end without a searing commentary on the lack of funding that exists for research in the family sphere. And we, again, Marcia Pruitt, Erwin Sandler, and Carrie O'Hara and Shara Wolchik, who I wrote the parent education chapter with, these are some of the top researchers in the field. They cannot get funded. There have not been, other than the folks at Indiana, there have not been really solid studies on mediation since Bob Emery's stuff in the mid 80s. And, we can throw all sorts of programs out there, but the reality is without decent evaluation research and without funding, which just isn't out there, it's going to be a problem. We're not going to know what works and what doesn't.
Well, that's been one of the big criticisms of the dispute resolution field. And I will say this isn't just family dispute resolution. You read the bibliographies of dispute resolution books, and they quote other dispute resolution people. And then you read the bibliographies of those books, and they quote dispute resolution people. So there's sort of like an amen chorus of people that want this to work and believe in it. But again, I think the critics, listening to those voices and listening to academics that are not associated with the field and who could do longitudinal research is really crucial for us to understand. And it's great we have research from the 80s, but it's a very different world now than it was in the 80s. And as you said, the practice of mediation, family dispute resolution has evolved a lot between here and there. So it is important that we have this funding so we can go back and ask and answer these big questions. But I think your book is a huge contribution in that direction too. It's not necessarily packed with empirical studies, but it is firsthand experience of people who are in the trenches doing this work. But Peter, what were you going to say?
Well, I was going to say there's another piece to this, and I think Kelly was alluding to it, which is that it is a highly politicized environment. There's a lot of gender stuff having to do with IPV, with parent-child contact problems, parental alienation, and there is can I use the term weaponizing research? There is a lot of contradictory research, people picking apart other people's studies, and it just creates a very polarized environment. And we don't do a lot of work in that area in this book, because I don't find it to be particularly productive. But it is out there. It is a part of the field, and we really do need to have people getting on the same page and sharing common definitions and common understanding of what the challenges are. It's very much, as I said, it's a lot like the politics we're looking at in our election today.
The other political, just to riff off of that for a minute, is what we've seen, unfortunately, is, and to start with, I absolutely and totally support joint custody between healthy parents who can co-parent effectively. But we have seen a huge push to have joint legal and physical custody without research that shows that it's better for children. There was research a long time ago that showed it is better for children to have both of the parents in their lives. And in some ways that research was bastardized to say it has to be 50-50, right? Absolutely, parents should have access to their children. But what we know is that when you create a law that says it's 50-50, except for very rare circumstances, then you are now creating a default that isn't healthy if those parents are fighting all the time. Because some of the long-term research that we have on children and children of divorce is that it doesn't matter to the children if the parents are married or divorced. It matters the level of conflict that exists over time. Right? So that's old. I'd like to have that up to, but that was a long-term study, or several long-term studies. So we now have these joint custody laws that is the default. But if that is creating more conflict, then we do know from a study that is worse for children. And so that's another place that research would be very helpful, to say what is the impact on the family? What is the impact on the children? That's key, right? But what about the expenses? What about people that are going to litigate because they don't get what they want because it's forced upon them? Because the studies that we do have from the 90s did show that mediation worked better for people. They were happy with it, and had less returning to court, recidivism, but not in the criminal sense of returning to court, than when a court made them do something. And that's in essence what these state legislatures have made people do, which is forcing joint custody on them, even if they don't want them, even if they don't want it. Both sides don't want it. So.
Very interesting. Very interesting. Well, again, I want to dive into all of these as we have more of these conversations moving forward in the podcast. I know Arnie did a piece at the end talking about, dealing with multiple codes of conduct.
I love that chapter.
Yeah. So I think the ethical decision making when there's conflicting guidelines, what are your takeaways from this book in terms of how we can best, shape the field and try and unify some of this guidance moving forward? Or do you think this conflicting guideline situation is gonna continue for the foreseeable future?
I think it will. I think that family dispute resolution is an inherently interdisciplinary practice. So whether you're a lawyer, a mental health professional, a social worker, psychologist, there's going to be conflicts in how you work through cases. As Kelly was mentioning, there are simple conflicts like, well, if you are, two healthy, happy parents, there's a joint custody or shared parenting time, versus those who are addressed, say, in chapter 12, the managing intractable conflicts chapter. And so there are always going to be conflicts, both in terms of ethical practices and in terms of just basic practice. And I think the beauty of Arnie's chapter is that he offers a model and a practice for walking through those conflicts and looking at the hierarchy of decision making to best meet the needs of the family. So his is not the definitive answer by any stretch. And I don't think there is a definitive answer, which is why I don't see that coming to an end. But what he does is give people a process for walking through it. And I think he's using domestic violence and mediation and mediation codes of ethics and psychology standards of practice, and they bump into each other. But he gives a nice way out.
Well, and the reason why I'm asking this is because I want the two of you now have gone through this multi-year process of working, with all the leading minds in family dispute resolution. I want you to look in your crystal ball a little bit. I mean, is there going to be greater clarity, greater coordination, or is there going to be more fragmentation? I mean, if in 10 years somebody needs to write the next version of this book, what advice will you have for them, and what world do you hope that they have to observe 5-10 years from now? Are you optimists? Are you pessimists? Are you a little of both? What do you think?
I think you can be an optimist and say there will be fragmentation, because fragmentation simply means that people who have different needs and expectations and temperaments and cases and situations find a process that supports decision making for their situation. Everybody can't have their own process. I mean, but if there's a spectrum that involves, again, decision making, information gathering, evaluation, self-determination, and each party gets input into what that process should look like, then I think we're hopefully giving the people what they want, rather than imposing a specific process on somebody for whom it might not be a good fit.
Kelly, what are your thoughts?
So I don't know. I think to mediate the answer, I think the good things that are coming are this interdisciplinary approach. And I really hope people can work from this. My concern is that mediation is in family law becoming a facilitated settlement conference. Attorneys don't like to deal with the emotions, so they just go to mediators that do a very good job in caucus all the time of facilitating the financials and the child custody. And the attorneys don't have to deal with the emotions or deal with the fear that their client's going to say something that can be used against them later, if they're all in the same room. And there's a role for that. But my goal when I mediate in these family cases, whether it's high conflict or not, is to figure out how to get this couple out of their intimate relationship into co-parenting or sometimes parallel parenting models, and work together for their kids over the next, whether it's they've got 5 years left or 15 years left or 20 years left till their child is an adult. By the way, they're still going to have to do it after they're adults, right, Peter? You still have to figure it out even after the child gets beyond 18. But I think that there's some movement towards that. I think the other movement is this expansion of mediation into other things, and expansion of how you define mediation, and really working with families. And I think that can take off, and the things that they talk about from the Wisconsin model, they talk about from the dispute resolution court, I'm positive about those things. I'm concerned about a different public and private model that's happening because of socioeconomic status, that some people are getting forced into a bastardized mediation model that gives them 45 minutes to an hour when there's a child support issue, that they put them in a room and say, resolve this, that isn't mediation, but still could be done as a settlement conference or something else. And they don't have time, and they may have one session, maybe two in North Carolina. It depends on the state and depends on the court. But then people who have a certain socioeconomic status can do it for as long as they want and whatever they want. My preferred model has always been to divide up the time and the topics, so we don't have to force everything through in a day. It's not everybody else's favorite, but if you've got people that are just coming out of a long-term marriage, they need time to process. And I don't want to prematurely help them solve their problem. So I think we're going to see the system separate out, and people with resources to get the very best are going to get an interdisciplinary organized process, and use things like collaborative law and figure out how to do things together. and have one expert instead of two where they can, work together. But for other people, and, I just was teaching this in class today on financial issues and divorce. It's harder to split up debt than it is to split up equity, right? If you have debt, you can't just say you take the credit card bill. If you have equity, you can split it up or you can figure out how to do it. And so when we've got people of a certain socioeconomic status, sometimes those cases are harder, but we're giving them less time. So I worry about that, but I think that there is the potential, Colin, you're a big part of that potential, to use AI, to use online processes that, a while ago, and you and I have had this conversation, I get very nervous about some of the aspects that happen when you have an online process, but I also think that can be tremendous benefits to it. And I think that will help us solve some of the financial issues and maybe, bring back a more unified process. But I'm curious about your thoughts, because I think we had a conversation once that you said you swore early on not to get involved with family mediation after someone suggested that it was too complicated, and you've come around. So what do you see as happening next with those steps?
Well, it's a great question, and I did decide very early on in my mediation career, this is not for me. I do not have the ability to separate myself from the emotions in these disputes. So I went in a very facilitative kind of transactional direction. But I work with lots of family mediators, as I say, and I've built software in conjunction with a lot of family mediation programs. I will not name the court, but I was invited in to do a training on the use of these technology tools for family mediators in a court that hires these family mediators directly to work, and they have a mandatory mediation model in this court. And I went in, and my slides were all based on all of what I knew about family dispute resolution, kind of best practices, white glove treatments, kind of the ideal in my mind of the way a family mediation works. And I started presenting my slides, and the mediators were looking at each other and chuckling. And I said, so, what am I getting wrong here? And they said, look, we do more than 1,000 mediations per year. And this office, it felt kind of like the DMV. And these couples come in, and these mediators, they don't do any caucuses. There's no confidentiality. They have a checklist. They have a clipboard, and they put a form on it, and the people come in and they ask questions and they check boxes, and that automatically generates, the parenting plan. And it was so far afield from my understanding of what we aim to do. And what I worry about is exactly what you say, Kelly. And I think technology has the potential of exacerbating some of these inequalities, where some people with the money, they get the white glove treatment, and Laura Wasser, gets them champagne and gets them a personal shopper, and they have all the attention that they need. And then other people get put into this automated process where they're just put into all these forms and they're clicking buttons, and they're not having any of the work that they need to go through the psychological journey of closure and being heard and feeling procedural justice and, making sure that all of the things that are important to them are included in the process. So I do worry about that. And I am a glass half full guy. I'm optimistic about technology because I think it can expand access to justice, but I also worry that we're going to, as the book says, automate the inequality and just put, the self-represented litigants into this automated process that doesn't provide any of the quality services that you describe in the book. So
I think
I don't think that's.
Go ahead, Peter.
Sorry, I was just going to say I don't think the process, whether it's technology based or face to face, can be held responsible for rectifying economic inequity. I mean, Kelly is talking about the child support programs, which I will mention. There's a chapter by Jessica Pearson and Nancy Thonis in the book, and even though these folks go in and get 45 minutes to an hour, they also, Jessica and Nancy, have done some really great research, and they are saying, you know what, they're getting a lot more than they otherwise would have gotten.
That's true.
They actually do appreciate it. And the same, I mean, and from technology, there's a great chapter that Donna Shostowski and Jen Shack wrote on the Ottawa County, Michigan ODR, the text-based ODR. And again, it's not, I don't think family dispute resolution processes or any DR processes are going to bring, people without means to a place where wealthy people are. That it's asking a lot of the process. What they can do is meet them where they are and try to make their lot a little bit better.
Mhm. Mhm.
Yeah, I think that's a really good point. And I wasn't looking at it as either the cure-all or the evil, but I do think it's sort of this balance, like Colin was talking about. There's positives and there's negatives. For domestic violence cases especially, there are positives where you don't have to be in the same room or even caucusing, but there's also the potential that you're being influenced that the mediator does not know. And
Mhm.
so, that's in the chapter that I wrote because I have concerns about it. But I think we also need to focus on what you just said, Peter, which is meeting people where they are. So as a story that I told before, I'm on the Arkansas Access to Justice Commission. I've been on it for over 20 years. And we had some of the first forums in the country that were how to help people with a very simple divorce, no kids, no property. You just fill out this, this
That's right.
form,
Sure.
turn it into the court, and it's great. And judges liked it until they didn't, because what people would do is they would go in and they create the form. And when it says, do you have children? And they say, yes. And it says, I'm sorry, we can't help you. Please, use these other resources. They would come out, they would come back in and they would say, no, we don't have children. No, we don't have property. They would go through, they would print out the paper and they would cross off no children and they would put their children in. And it changes everything, but all they did would take that to court. And so we got a lot of complaints from judges and from clerks about how the paperwork wasn't right. Well, the paperwork was right if you filled it out correctly. And so we've since expanded them and they're better, they can help a bigger variety of people. But I do think that we have still gaps. And I think that's, Peter, I'm so glad you brought up the research that we have in the book and the things that are working on this. My sister's had worked on this for a long time in Milwaukee. Some things are better than nothing. And helping people to talk about things can be incredibly helpful, but I do think that there's more we could do. And I would love to see how technology can play a role in that and on the helping. It's not going to fix anything and it's not the evil either. It's how it's used, right? It's the old garbage in, garbage out that goes way back in terms of how are we using this and what kind of tool is it? And I know one of the things, Colin, you've said is the fourth party in the room. How is that fourth party helping?
Sure. Well, people say to me, it's so creepy that you help people get divorced on a website. And I say, well, how do you think marriages happen these days? It's all swiping left and swiping right. I mean, so when you think about 10 years from now, the person that updates your book, they're going to have Siri divorces and say, Siri, we want to get a divorce. Okay, let me start asking you some questions. So,
well, and isn't that a little old school with some of the older
right.
Islamic tradition that was, I divorce you, I divorce you, I divorce you. And Siri hears that and goes, okay, I'll file the papers.
Yeah.
I mean,
That's right. That's right. What old is new? What is old is new again. So, well, look, I want to respect our time here because I only booked you for an hour. I could do this. I could easily go another hour. I have so many questions I want to ask the two of you. But I will say, as an author in the book, one of the reasons why, Peter, you said one of your the things you learned was sort of the passion and commitment that nobody's making any money on this book. I figured you were retiring because of all the proceeds you got from your big contract here.
Yeah.
But one of the reasons why I think all of us stepped up and contributed to the book is because of the two of you. And because we understand your passion for this and your long history of working in this field. And we were inspired to be involved with the project that the two of you would lead. So this is an incredible contribution to the field. And I know it was an enormous amount of work. And I'm so impressed that the two of you still love each other, even after you had to hurt all these cats, because I know it was painful. But I think that's the reason why this came together, was because we all understand your why and we understand your passion and your commitment to this. So I want to thank you for that. And I want to thank you so much for taking the time to chat with me today. And I can't wait to do this project and interview all the different chapter authors. And I think it's going to be fun for you to listen to these as well. And
we'd love to do, if it's possible, Colin, is after we talk to people and you interview them or I interview them, we have other people do the interviews, but I would love to come together at the end and kind of say, sort of, as you said, what have we learned from the chapters, but what do we know now that what have you learned now that you've interviewed people? What have we learned is come, because I think that these are great, as Peter has emphasized, we just have a bunch of great people who are doing great things beyond the book, but are passionate about these topics. And I think people will learn a lot on the podcast, and sort of like the book, pick up a topic that you're interested in and that you think you know a lot about, but also listen to an author who's in an area that you don't think has impacted you, or you don't know much about at all, because like I said, I learned editing these chapters, and I think everybody can learn from the author. So I'm very excited about this podcast series and would love to revisit at the end.
Fantastic. Peter, why don't you take the last word?
Right. This book has been a life's work, really has. I think it's reflected the changes that have happened in my career and Kelly's career. Kelly's is still going. I'm kind of stepping away. But I think that it's just an indication of the creativity and the passion that people in this field have for helping families. And, we haven't said that yet. So I think it's a great thing to end on, which is that really all the people who are writing for this book are dedicated to helping families and children, and hopefully this book will go some ways to making the system better for them.
Yeah,
Absolutely.
I think people who go through divorce are not on plan A, and they tend to think other people are, but most people are on plan B, C, and D. And so everybody that's involved in this book, from you, Colin, Peter's original idea of it, we're trying to make the next stage, the next step, the plan B or D or even Z work for the families and the kids. So, and I just want to say, I get the last word, that I so appreciate Peter bringing me into this project, because it was his vision. It's been his vision throughout his career to help people. And he's really setting me and AFCC up well with this book and with everything he's done over his career to help families and to help families figure out what's next, because it's a scary world a little bit when you're moving to plan B, and this book and what he's done at AFCC has been incredibly helpful.
Amen.
Thank you, Kelly.
All right. Well, thanks to you both. This was a wonderful conversation, and I really look forward to furthering this series with the both of you. So thank you so much.
Thank you, Colin.